Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. In my previous video, I talked about certain basics of patent law in India. In this video, I will be talking about the rights and obligations granted to the patentee in India. In India, the owner of an invention is required to get his or her invention patented under the Patents Act of 1970. The registration of patent provides certain rights to the patentee, which is mandatory to be followed by the patentee. With rights also come certain obligations which are required to be followed by the patentee. Hence, the Patents Act of 1970 provides both these rights and obligations. Now, who is a patent holder? A patent holder is basically a person who invents a procedure or product whose exclusive rights and obligations are granted to him as an inspiring force for investment in creative or inventive exercises and for the spread of such exercises in public at large for learning. However, these exclusive rights and obligations of patentee are not unending and can be revoked. Now, what are the benefits conferred upon the patentee of a patent? In India, the patent law identifies the exclusive rights and obligations of patentee to gain certain commercial advantages out of the invention invented by him or her. Such rights and obligations are provided to boost the inventor to invest in the new innovative ideas and should realize that the developments done by them will be unshod and protected by the law and hence no other person has the capacity to make a duplicate of such inventions. Such a protection is provided for a certain time period, for the most part 20 years, amongst which the inventor will have certain selective rights and obligations of patentee as per the Patents Act of 1970. Now, what are these rights of the patentee? First is the right to exploit the patent. When the new invention is a product, the patentee has the exclusive rights to use, make, import, or sell for these purposes related to an invention in India. On the other hand, when the invention of the inventor is a procedure or process of manufacturing of any article or substance, the right to exploit means the exclusive right to use the procedure or method in the territory of India. Right to grant license. The patentee of a patent is given the right to grant license or transfer rights or enter into some arrangement for some consideration. The assignment or license is to be valid and legitimate. It is required to be in writing and should be registered with the controller of patent. Unless a document of assignment of a patent is not registered, it is not admitted as evidence of title of the patent, and such a rule is applicable to the assignee, not the assigner, as per section 69, subsection 5 of the Patent Act of 1970. Next comes right to surrender. By giving notice in the prescribed manner, the patentee of a patent has the right to surrender a patent at any time and at his or her own discretion. The advertisement for such an offer of surrender is required to be done in the journal. The publication is done to give an opportunity to the people to oppose the offer of surrender of the patentee. This is done when the patentee apprehends his or her non-performance of the patent in the future and upon which he or she decides to surrender the patent. Next and the most important is the right to sue for infringement. The patentee has the right to sue for infringement of patent in the district court has the jurisdiction to try the suit. Next is the right to use and enjoy patent. The patentee of the patent has the exclusive right to exercise, make, or utilize, or convey, or offer the patented substance or article in India, or to practice or utilize or the process or the technique associated with the invention. Such rights can be exercised either by the patentee himself or herself or by his or her licensees or agents. Now, what are the obligations under the Patents Act of 1970? Once a patent is granted to a patentee, there are certain rights and obligations of patentee, which are as follows. First is the duty to disclose. Section 8 of the Patent Act 1970 accomplishes the obligation to disclose the patentee and, and gives an obligation to disclose all required data related to the remote uses of the same invention documented by him or her, through him or her, or by someone else at the time of applying, or within 6 months of applying. The patentee of a patent is required to record an announcement of all the listed particulars viewing the applications, and in addition to the above, an endeavor to disclose all the points of interest of any subsequent applications that might be documented at the future stage. Next obligation is the duty to request for examination. Not like other intellectual properties, the registration process of the registration of patent does not accommodate any kind of programmed examination of the grant of patent application. In the procedure above mentioned, as indicated by Section 11, subsection B of the Patents Act 1970, the obligation is thrown on the patentee himself or herself to ask for the controller of patents to look at the growth or development connected in the case of the patent. Next comes the duty to respond to objections. The controller of patent, before accepting the examination request, passes it to the analyst who looks at the growth and gives a report to the controller of patent, known as the first examination report. On certain cases, there may be some protest which will be brought up in the first examination report. It is the right of the patentee, or right, or I would say a duty of the patentee to reply to such opposition or complaints as mentioned in the first examination report. Next comes the duty to clear all objections. It is the obligation of the owner of the patent to respond to the raised objection as well as to clear and remove each one of the raised objections, and in addition, certain oppositions raised against his or her invention. In the event that the controller of patent has not fulfilled he or she, it may also require a meeting also. Furthermore, it is the obligation of the owner of patent to go for a consultation and clear all objections against the invention. Next comes the duty to pay the statutory fees. The patentee has an obligation to pay all the statutory fees required to get a grant of patent in the process of registration. Section 142 of the Patent Act 1970 provisions and recognizes payment of charges in addition to the consequences for non-payment of such prescribed fees. Thank you so much for watching the video, and please subscribe to the channel for regular updates.